Definitions of the most commonly used estate planning terms. Hi, everybody. I am attorney Michele Conti. I am an estate planning attorney here in Pittsburgh, and I'm always asked, what's the difference? So we have an agent. That's the person you've appointed under your power of attorney, whether financial or medical, who will manage your affairs if you're unable to do so. The creator of the power of attorney is called the principal. That's you. The creator of a last will and testament is called the testator. Again, that's you. Under the will, you will appoint an executor. That's the person who will administer your estate and settle all of your affairs upon your passing. We also have beneficiaries. They are the people who ultimately will receive what's left of your estate once your executor has paid all of your debts and the taxes and the fees associated with your passing. Now, if you pass away without a will in Pennsylvania, we follow what's called the intestacy law, and your next of kin will pick ultimately somebody who will serve as the administrator of your estate. Very same role as the executor, just different term because you've passed away without a will. Now, in Pennsylvania, we have what's called intestate law and testate law. Intestate means you died without a will. Testate, you died with a will. Now, if you have a trust, you can have what's called the grantor or the settlor. That is the person or the people who have created the trust. You have the trustees. Ultimately, they are the people or the person who is managing the trust assets. And again, beneficiaries, those are the people who inherit from the trust when you pass away. With a more advanced trust, you may have what's called a trust protector. That, again, is the person or the people who ultimately will have the final say when making modifications, changes, withdrawing principal from an irrevocable trust. A revocable trust is a trust that can be amended or modified over your lifetime, over the grantor's lifetime, and at their behest. An irrevocable trust is a trust that on its face cannot be changed. Now, of course, there are exceptions. You can modify an irrevocable trust, and you would do so by having all of the beneficiaries, primary and contingent, as well as the trustees and trust protectors sign off. At last, we have guardianship. Guardianship is when somebody cannot sign a power of attorney. We will go through a guardianship process with the court. We have a guardian of the person. That means that ultimately you are appointed to manage the incapacitated person's medical decisions, and a guardian of the estate, which is the person who will manage the incapacitated person's financial estate. Financial decisions will be made.